question about the case.
Ms. McHenry, sit down. This is not your courtroom. Sit in that chair.
I have a question about the case. That's not the case number that I had.
Yes, it is, Ms. McHenry. You've got other cases pending that are set for jury trial.
Hey guys, and welcome to today's video today. I have a treat for you, as we have 4 different sovereign citizens in 4 different courtrooms. 2 of them are updates to cases I've already covered, and 2 of them are new. We'll start with everyone's favorite soft Eric Martin. If you remember, only a few weeks ago the court was prepared to let Eric Martin out of jail on a PR bond. However, Eric Martin couldn't enjoy his right to remain silent long enough to enjoy his right to be released from jail cell. He's been stuck there the whole time, so let's begin.
Good afternoon, Your Honor. Don Silva on behalf of the people, PA 7439.
Nicholas Darren on behalf of the defendant, Mr. Martin, who appears before us via Zoom. Mr. Martin, if you could unmute yourself and state your name for the record.
Very good. Okay, I got it.
You got it.
All right, you hear me?
Yep.
All right.
So this is People versus Martin.
Yes, Your Honor. I have spoken with the complaining witness at the time. He would like to proceed with this case, and the people would ask to set it for a settlement conference before we go forward with the trial to see if there's a resolution.
All right. And Mr. Darren?
I mean, Your Honor, I guess we're gonna proceed that way. I was hoping, I'll renew my motion from the last time. Mr. Martin's been incarcerated, I think it's like 62, 63 days now. Court rule is pretty clear. If he's in over 28 days, he should be released on a personal bond. Mr. Martin's just been sitting in jail on this matter. I mean, I guess from practical, I would imagine the court's going to give him credit for time served, regardless of what the resolution is on this matter. Considering he's done over, at this point, he's done over 2/3 of what his original sentence would be. We're not going to accept an offer on this, and I guess we'll just set it for a settlement conference then, if that's what sister counsel wants.
And Your Honor, it's I know this case has been going on for a while.
Personal bonds.
That's correct. The issue here is that him and the victim are brothers. They live at their family
First,
home.
I want to deal with the whole bond thing, because
Yes.
his bond is $2,500 personal.
So I think the issue with that is I was having a cover last week, but per the notes, if you recall, you ordered him not to return back to the property because there's a no contact order in place. 2 weeks ago, when Mr. Brother Counsel appeared for the first time on this case, I believe I agree, and that's when the bond was changed. But Mr.
Who changed
Martin,
the bond?
Judge Kirsten. Yes.
So, Your Honor, Judge Kirsten changed his bond, and then after some further statements were made, he changed his ruling to leave Mr. Martin in jail.
And that's because Mr. Martin made comments about returning back to the location, the home where the victim lives. And to my knowledge, per my conversation with Mr. Martin, the victim today, he indicated he'll be leaving the hospital, returning to that house tomorrow.
Right. All right. So I'm going to.
I mean, I have no objection.
Mr. Martin, now listen, you understand, I wasn't here, but Judge Kirsten, the original bond was $2,500 personal. Then he set it at $2,000 cash because of the alleged violation that says it says need to set a hearing on violation ASAP. I don't know if there was I don't see anything on whether there's an alleged violation of the bond condition. Is that right?
Not an alleged
Or the
violation.
alleged was
He
just,
made comments
he made a comment about
that
it.
he'll return back to the house.
Which is why something. All right, so you understand you can't go to that house while you're on that. That's while the bond's in place. You understand that? Stay somewhere else. You understand that?
No, I do not understand, and I gotta stand up. First, I have nowhere else to go. Okay, so that's why I must return back there, and I objected. No, let me talk.
You sure you want to do that error the last time you ran your crayon recycler? You ended up talking yourself out of being released from jail. But I'll give it to Eric Martin, though he does by his own delusions. and is 100% stuck on stupid.
I objected to the bond conditions before, I'm objecting to them now under the due.
Listen, your objection is duly noted. You have very, very highly competent counsel, so we'll just let your counsel speak in your behalf. And so he already did. He made a motion.
Well, I object to you speaking on behalf of that.
Stop interrupting me, sir. I'll just hold you in contempt of court for 90 days, and then you can just sit there anyway for it. Stop interrupting. Your Mr. Madera made a motion to set this for a personal bond. I'm going to set your bond at $2,500 personal. No contact with the victim or the victim's home location. And if you show up at that location and violate my bond, you can be held in contempt of court. Just want to make sure you understand that. I'm just telling you that right now. So I'm setting your bond at $2,500. I'm granting the defendant attorney's motion. And the bond's $2,500 personal. No contact with the victim. And no live in the state of Michigan without the consent of the court.
I got something to say.
And you have a right to remain silent, and anything you say can be used against you, and you already have an attorney who's talking on your behalf, and I've already granted his motion and changed the bond to personal, so.
Hey, well, I have something to say in response to that.
See everybody at trial.
I have something to say in response.
We'll see everybody at trial.
Your Honor,
Mr. Darren, do you have anything else further?
Your Honor, are we going to set it for a settlement conference, or are we just going to set it straight for a trial?
Sure, I'll set it for a settlement conference, and then a week later it'll be the trial.
All right. Your Honor, I understand the court's position. I mean, if Mr. Martin wishes to make a statement on his behalf, I can only advise him that I wouldn't. But if Mr. Martin wishes to make a statement and the court wishes to hear it, I don't have any. I mean, I'm not going to. I'm advising him not to say anything. But Mr. Martin, if the judge wants to hear it, if he's allowing it, then I'll step aside and let you state.
Mr. Martin, I've already granted your attorney's motion to set the bond at $2,500 personal. So if you have some other statement you want to make, I'm just going to reassure you again that you have the right to remain silent. Plus, your attorney's already said that, hey, you know what, it's probably a good idea to just do so. But go ahead.
Yes. Like I said, I'm going to exercise my First Amendment right to speak, and I have a lot to say, so I ask that you don't cut me off or I'm done talking now. I object to the bond conditions and stuff. I can't be in my house. It violates my due process rights. I have nowhere else to go, and he's not the true victim. He's lying, saying he's a victim, but I told the cops when they arrested me that I was the victim. And so we have an equal protection clause violation.
All of that'll be the subject of the trial itself, so we'll hear everything you have to say about that at trial. Your objections duly noted. But that doesn't change my positions.
How much do you guys want to bet me that Eric Martin will not follow his bond conditions? He'll be rearrested within a month, and eventually he's going to get convicted, and all these bond violations and refusals to follow court orders will be used against him during sentencing. So now we head to our next brain donor, which takes place in Coronado now. This is a continuation of a sovereign citizen Karen that I've covered before whose really pushing the patience of an extremely explosive judge hears. Just a snippet of the last hearing to get you all caught up.
Take a seat
I have a question.
in this blue chair.
Do I have the
Sit down.
Do I have the same rights?
You want me to hold you in contempt? Sit down. In that blue chair.
Do I have the
Sit down!
rights there?
One more time. Sit down. You are charged with one count of no operator's license, a minor misdemeanor subject to a maximum fine of $150 plus court costs. You also are charged with one count of expired plates, also a minor misdemeanor subject to a maximum fine of $150 in court costs.
I am the authorized agent to the decedent estate. I am coming in here as the settler, and I want to settle this case.
I will enter no plea on your behalf to these charges. I've given you 3 plea options to plead.
No, I do not recognize anyone in this court.
Okay, well,
I don't recognize you or the bailiff or anybody else in this court. Then I'm just going to surrender the person to the court because I'm not coming back.
I don't know what that means.
You do know what that means.
I don't know what that means.
I am not the ens legis. nom de guerre.
I've been practicing law for 36 years, and what you've just said to me has no meaning to me whatsoever. So let me say it one last time, because we have other cases to handle today. If you don't leave the courtroom and go to the clerk's window and give a trial date, which is what I'm scheduling in this case, I will hold you in contempt of court and I'll have you arrested. You either go to the clerk's window now and get a trial date, or I'll have you taken into custody now. You got it?
Well, unfortunately, she didn't get it something to note. She's only being charged with 2 minor traffic crimes that have a total fine amount of only $300 with 0 jail time. Remember, that is, she does everything in her power to be arrested.
Court is now on the record in City of Conneaut versus Amber McHenry, 24 TRD 819. Ms. McHenry entered no plea to charges of no operator's license and expired plates, each of which is a minor misdemeanor, on December 17th, 2024. I scheduled it for a bench trial for January 8th of 2025. Ms. McHenry was given notice of that bench trial. I have a signed receipt in the file showing she got notice of that bench trial. Present on January 8th, 2025 was the law director along with a police officer. Ms. McHenry failed to appear. As a result of her failure to appear, I issued a warrant for her arrest. That was January 8th. It's now over a month later, February 11th, and Ms. McHenry is now turning herself in on the warrant. She's in the courtroom, and she is without an attorney. Ms. McHenry, why were you not here on January 8th of 2025?
I have a question about the case.
Ms. McHenry, sit down. This is not your courtroom. Sit in that chair.
I have a question about the case. That's not the case number that I had.
Yes, it is, Ms. McHenry. You've got other cases pending that are set for jury trial.
The original case number that I had was like TDR, like 0800 something. And
24 TRD 819.
819. Okay. I was just double checking on the case number. Can you repeat your question then? No.
Why were you not here on January 8th?
I put in an appearance and it was rejected and struck from the record, and I was sent a letter saying that I am not who I said I was. So I have a question about that because I don't understand.
This is not a discussion here. This is not a conversation. I ask a question, you respond to my question. Now, this is typical behavior for you because you're a sovereign citizen. At least you claim to be.
I've never claimed.
Yes, you have. You may not say it out loud. And you may think like the rest of us that sovereign citizens are an endless fountain of uneducated entertainment, and that there's no possible way that you're that stupid Karen, but one does not have to identify as a sovereign citizen to be a sovereign citizen. All you have to do is demonstrate a lack of functional brain cells and a propensity to run face first into brick walls, and currently you're doing both.
Well, your documentation that you filed, including the one you filed today that did not have a correct caption or case number on it, is indicative of that. So let me ask you, Ms. McHenry, again, why were you not physically, personally present in the courtroom on January 8th, 2025 for your trial?
I need the oath and bonds to be put for each person acting as a public official in this case who is acting as a public servant to be put on the record. And I also require the indemnity bond, and I'm going to require the other bonds. I need the accounting. Please, for the record, let it be known that you exited.
I
Well,
did.
asking.
I exited the courtroom and asked a police
Who
officer,
is-
probation
Who has
officer.
the
to come
indemnity
back.
bond? Where is the bill of particulars?
The
Because
bond
I
is
did not
being,
receive it.
the warrant is being executed, you're being taken into custody. Take her down to the jail now.
I was not given the warrant.
Take her down to
either.
the jail now.
Why am I being arrested?
Take her down
For
to the
what?
jail.
What crime have I committed? Get off me. This is kidnapping. This is a false arrest.
Stop fighting.
No, this is a false arrest.
Okay, relax.
This is kidnapping. They're violating my rights, my constitutional rights. I put in,
I thought the Constitution didn't apply to you.
the Constitution applies to every living man and woman.
Yeah.
You are violating your oath, Mr. Iarochi.
And you remember what I said at the beginning of this video? Her maximum possible fines combined was $300 with 0 jail time. I mean, I guess I didn't realize that when you were a constitutional freedom fighter, it meant that you would be unconstitutionally fighting against your freedom now. For our third hearing, we dropped down to Texas, where we have a man who purchased a foreclosed